5 seconds to go. Start. However, from the averments in the application for condonation of delay, we are of the opinion that it was a case of a gross negligence and or want of due diligence on the part of the respondents herein appellants before the High Court in filing such a belated appeal. We have gone through the averments in the application for the condonation of delay. There is no sufficient explanation for the period from 15th March 2017 till the second appeal was preferred in the year 2021. In the application seeking condonation of delay, it was stated that she is aged 45 years and was looking after the entire litigation, and that she was suffering from health issues and she had fallen sick from 1st January 2017 to 15th March 2017, and she was advised to take bed rest for the said period. However, there is no explanation for the period after 15th March 2017. Thus, the period of delay from 15th March 2017 till the second appeal was filed in the year 2021 has not at all been explained. Therefore, the High Court has not exercised the discretion judicially. At this stage, a few decisions of this court on delay in filing the appeal are referred to and considered as under. In the case of Ramlal, Motilal and Chotelal Supra, it is observed and held as under. In construing section 5, it is relevant to bear in mind two important considerations. The first consideration is that the expiration of the period of limitation prescribed for making an appeal gives rise to a right in favor of the decree holder to treat the decree as binding between the parties. In other words, when the period of limitation prescribed has expired, the decree holder has obtained a benefit under the law of limitation to treat the decree as beyond challenge, and this legal right which has accrued to the decree holder by lapse of time should not be light-heartedly disturbed. The other consideration which cannot be ignored is that if sufficient cause for excusing delay is shown, discretion is given to the court to condone delay and admit the appeal. This discretion has been deliberately conferred on the court in order that judicial power and discretion in that behalf should be exercised to advance substantial justice, as has been observed by the Madras High Court in Krishna versus Chhatappan 1890 JLR 13 Madras 269. Section 5 gives the court a discretion which in respect of jurisdiction is to be exercised in a way in which judicial power and discretion ought to be exercised upon principles which are well understood. The words sufficient cause receiving a liberal construction so as to advance substantial justice when no negligence nor inaction nor want of bona fide is imputable to the appellant. In the case of P.K. Ramachandran Supra, while refusing to condone the delay of 565 days, it is observed that in the absence of reasonable, satisfactory or even appropriate explanation for seeking condonation of delay, the same is not to be condoned lightly. It is further observed that the law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribes, and the courts have no power to extend the period of limitation on equitable grounds. It is further observed that while exercising discretion for condoning the delay, the court has to exercise discretion judiciously. In the case of Pundalik Jalam Patil Supra, it is observed as under. The laws of limitation are founded on public policy. Statutes of limitation are sometimes described as statutes of peace. An unlimited and perpetual threat of limitation creates insecurity and uncertainty. Some kind of limitation is essential for public order. The principle is based on the maxim, that is, the interest of the state requires that there should be end to litigation, but at the same time laws of limitation are a means to ensure private justice, suppressing fraud and perjury, quickening diligence and preventing oppression. The object for fixing time limit for litigation is based on public policy, fixing a lifespan for legal remedy for the purpose of general welfare. They are meant to see that the parties do not resort to dilatory tactics but avail their legal remedies promptly. Salmond, in his jurisprudence, states that the laws come to the assistance of the vigilant and not of the sleepy. Stop.